Hello, everyone. My name is Ariella Wagner. I'm the founder of SunRay Construction Solutions, a national construction document service. We help thousands of general contractors, subcontractors, and suppliers secure their lien and bond claim rights. Today, we have a fabulous webinar conducted by Mark Cobb. He has over 25 years of construction law experience. He remains active in many professional organizations and speaks on the mechanics and Materialman's lien laws, bond claim laws. And without further ado, I would like to introduce Mark Cobb.
Thank you, Ariella, and thank you for everybody who is listening to this video live and for those who will be watching it in the future. Again, Mark Cobb, and I'm going to try to make this fast. I know we're trying to keep it down to about 20 minutes. And we also want to have times for questions and answers on the back end. So we will get to your questions, and I'll stay on as long as we need to get to everybody's questions. I think if you don't mind, we will wait to the end. And we do remind you, when you post a question, do not include your name or your company's names into any questions. So I've been doing construction law for over 25 years, as Ariella said, and it is interesting. I have learned a lot about payments. That's sort of my particular area of expertise: payment bonds, Materialman liens. My very first client was a national equipment company. I worked directly with the regional manager and learned a lot about the business side of what you guys do. And of course, as a young lawyer, I was learning the legal side about what needs to be done. From that small first client, I got another large national supplier. I think the original credit manager left and went to 2 other companies. I kept them. So my career really was focused early on in helping material suppliers. It then expanded, of course, into helping subcontractors when I wrote a book on subcontractor law, and then went to general contractors, and we do a lot of owner work now. So our firm has grown. Our entire firm does nothing but construction work. And we've learned that when it comes to payment, you have to start day one. There's an adage, the squeaky wheel gets the grease, and that is so very true with payment. If you wait until after you send your last invoice and you give them 30 days or even 10 days, it doesn't matter, and then you try to collect your money and they don't want to pay, you're probably going to have a very low success rate. On the other hand, if you start every single day with considering what you can do to help improve your payment options, if you continue that through the project life of the construction project, and then if you then continue it through the point of final invoice and retainage, your odds of recovery are greatly increased. So we're going to be looking at those 3 areas today very briefly. We're going to look at preliminary considerations. Then we're going to look at what you can do during the project life. And then finally, we're going to look at what to do after the project is over. So preliminary considerations. This is when the customer walks into your door if you're a supplier. This is also if you're a subcontractor or contractor, when you're contacted and you're requested to create a bid or to participate in a project. There are so many more things we could talk about, but I'm going to talk about 5 things today. First, about building relationships, defining the scope, understanding limits, and then we're going to spend a little bit more time on due diligence and contracts. Building relationships seems obvious, but it is absolutely vital in the construction industry. There are so many startup companies that it can be very difficult to understand who your customer or who your client is, and you need to understand them on both directions. If you're a subcontractor, you need to build a relationship with the general contractor and with your subs or your suppliers. Those relationships go a long way to making sure that you get paid. One of my best clients is a general contractor. I call him best clients. He really rarely gives me any work. Occasionally I'll revise his contract for him. But he's a large regional contractor working on schools and college campuses and hospitals. But he refuses to use any subcontractor except those with whom he has a relationship. He has virtually 0 payment problems and virtually 0 completion problems with his subs. It's that relationship that allows the success on his projects. And that can be true no matter which tier you are on your construction project. Understanding and defining scope, that is probably the biggest problem area we see as construction lawyers when it comes to payment issues. There's to have a binding contract, there must be a meeting of the minds. And as you can imagine, on construction projects, defining the scope can be difficult. It should never be a sentence, remodeling an apartment. It should be detailed and actually define what is included in the price. And even better, it should mention what is excluded in that price. And if you do that, also say that the following is a partial list of items not included in this contract. If you're supplying materials, it's important to know the quality of materials or the grade of materials. It's important to know the size of the piece of equipment. Whatever it is, in the very beginning, make sure there's a meeting of the minds and that you have understood what the other party wants from you, and then you're able to define it adequately in writing. Understanding your limits, that's sort of a tough one to talk about sometimes. I learned a long time ago, actually it was during the Great Recession. I went to multiple seminars, and in those seminars, other construction experts across the country pointed out that more construction businesses go out of business during boom times than they do in recessionary times. It sort of defies logic, but when you begin thinking about it, it makes sense. In boom times, prices go up. In boom time, labor is difficult to find. In boom time, people enter the industry that really don't belong in the industry. In boom times, people say yes to projects when they should have said no. So people stretch themselves too thinly. So no matter what your business is, whether you're a mom and pop operation or whether you're a national business, you need to understand what your limits are, what you can actually deliver, and what you can actually do. It is far better to say no to a project than to take on a project and have that project go upside down on you. And just as a point of notice, as construction lawyers, we are seeing right now a significant number of payment problems coming from people who said yes to projects to which they should have said no. Boom times, they're staying busy, they want to stay busy, they say yes, 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 and they can't complete the project, they don't have the manpower, and it's becoming a serious issue within the industry. Now, the last two preliminary considerations, due diligence and contracts, I'm going to dive into just a little bit deeper. Each one of these you could easily spend an hour on, and we've done seminars on that. But due diligence is something you need to do at the very beginning. It is so important to get basic information about with whom you are working. I can share you story after story where clients contact me at the end of the project, they haven't been paid, they want to file a lien, and they give us the name of the business. And maybe it's, I'm making up a name here, but it's Subcontractor 1. And that's all they have. Well, I go to the Secretary of State's website to learn who Secretary 1 is, and guess what? They are not there. There may be Subcontractor 1. There may be Subcontractor 101. There may be Subcontractor 1A. There may be Subcontractor, but the name they gave me doesn't exist. So who is actually the client? Furthermore, a lot of those companies that are named similarly are owned by the same people, and they've created different entities, frankly, I think, to confuse things. So it's very important to get the actual legal name, go to the Secretary of State's office and confirm that it exists, and understand the entity type. Also, when people come into your counter or when they're first asking you to bid a project, it is so easy to get information from them. You should have adequate credit apps, for example. Get the business's tax ID number. Get the owner's names and get their contact information. I mean, I have recommended to clients, depending on who their customers are, but get the owner's residential address, get the owner's social security number, get their spouse's information. That is all information that seemingly is not important to begin the process to deliver materials or to do subcontractor work, but it is very much a part of the process of collecting money. Get the current bank account information. If there's a deposit, make sure there's a copy of that check. credit apps, have who their banks are, and verify that information. Having that information can lead to a garnishment, which leads to recovery. A couple of things we see most people don't do are pending or prior pending lawsuits. It is relatively easy online to check and see what prior lawsuits are out there, what pending lawsuits are out there. That way you get some idea of the litigiousness of the entity with whom you are working. So if you see somebody who has had multiple lawsuits, it might be a red flag that says, hey, we shouldn't work for this guy. Similarly, the lien docket in most states, pretty easy to use. In Georgia, it's easy to use. We look for it for clients when they ask us to help with due diligence. One of the first things we do is do a statewide search of all the liens involving that contractor. It can tell us if they're not being paid, so maybe they aren't doing due diligence on the GC or the owner. It also tells us if they're not paying their subs or suppliers, if I see liens against them, even if they get paid off. If there's a bunch of liens out there, that's a red flag. And that may mean you don't want to do work with them. It may mean you want to do work with them in a different way. You want to secure yourself. A great question to include on a credit app, and you want verification of this, is, are they bondable? So for those of you who don't know, if a surety is willing to bond a contractor or subcontractor, that means the surety has already done some of this background work for you. In fact, they've done quite a bit of it for you. They've looked at past projects. They've looked at pending and past lawsuits. They actually have information on the owners and the owners' addresses and even the owners' relatives. And so if they're bondable, it's not a guarantee, but it does give some additional assurances that maybe this would be a good customer, good client, good contractor to work for, and someone who will pay their bills. And then another big one that people just don't seem to do, but you want to look at the success of the past projects of your customer or your client. Again, when we do this for clients, we'll pick up the phone and we'll ask the owner of the project, hey, how was such and such contractor? Did they pay their subs? Were there any liens against the project? How was the performance? Were you happy with the project? Again, that's a great indicator of the quality of the person with whom you're working. Contracts, another big thing, part of due diligence. Contracts are so important. If you have a one-page written proposal, that's going to be interpreted differently than if you have a solid contract to look at. When you're looking at contracts, and again, there are books written about this, and you can do multi-day seminars on contracts. But some of the highlights, you want to make sure you understand the risk involved. In today's construction industry, owners want to push as much risk as they can on the prime contractor. The prime contractors, in turn, want to push the risk down on the subcontractors. Subcontractors want to push it down on the subcontractors. It is absolutely ludicrous that the arguably the biggest companies, the prime contractors and the owners, push so much risk down to the presumably smallest companies. So you have to understand the risk. Also, understand the payment process. Is there an interest provision in there that allows you to collect interest if you're not paid timely? What happens to amounts in dispute? If you present something, are they going to give you partial payment? Are they going to give you full payment? Or is that money going to end up in escrow? What's going to happen through the life of the project if a dispute arises midway through? And then also, how you're going to resolve disputes regarding payment. Is there an architect in there who makes an initial decision? Is there an appellate process? What is it you're going to do? Similarly, just in general, you want to make sure the contract has a spelled out dispute process. So with payment issues in particular, we find that mediation is a very important component of your terms and conditions. If you have to file a lawsuit that involves hiring a lawyer, and you're likely going to pay tens of thousands, if not even more, to get to a lawsuit, get through motions, and get to some point where maybe you'll get some money back. Mediation can be done quickly. I've seen it done as quickly as 1 week. Hey, there's a problem. We need to call a mediator. Let's see if we can get in. And you get issues resolved. You can also have an arbitration provision, not as fast as mediation, but definitely less expensive than litigation. In the dispute process, you want to know about deadlines. Do you have to give written notice? How long do you have to make a demand for arbitration or demand for mediation? If you make that demand, then when does mediation or arbitration occur? Does this dispute process include attorney's fees for the victor? Do you want that? And very important, does the dispute process include a convenient jurisdiction or choice of law? So if you're a Georgia company working on a project in Los Angeles with a contractor of Illinois, which state laws apply? And then where's the jurisdiction? Where are you actually going to have mediation, arbitration, or litigation occur? Those things make a big difference as to how much money you spend to collect your money. I mentioned earlier, if due diligence reveals something negative, you may want to do things a little bit differently. Two very obvious but common ideas is make sure you get a personal guarantee. I worked one time with somebody who had a contractor they wanted to work with, but the credit just wasn't there. The project success just wasn't there. So we ended up getting 6 personal guarantees, one from each of the owners and their spouses so that they couldn't transfer assets. Also up front, you can think about getting a joint check agreement. If there's any question whatsoever, you can go to a higher tier and say, hey, we're willing to supply, we're willing to do work, we want to work on this job, but we're very concerned about the payment. Will you joint check us? During project life, there's also very important considerations you have to do. So Georgia does have a statutory notice scheme. And so if you're a subcontractor or a material supplier and you supply to a subcontractor or lower tier, then within 30 days of the day you start that project or start the deliveries, you must send a notice to owner and a notice to contractor. And of course, Ariella and SunRay, that's exactly what they do. They do a great job, but that's very important. If you do not do this, you will not have lien rights or payment bond rights. So again, within the first 30 days, you must send an NTO that is sent to the owner and the contractor. And all it says is, hey, we're on the job. You now have to track the payments down. We're a subcontractor. We're a supplier to a subcontractor. You don't know who we are. The general contractor may not know who we are, but now you've been given notice. Track the money from the owner to the prime, to the first sub, to the second sub, to the supplier. Also, if their due diligence has revealed some concerns, Georgia allows you to file preliminary liens. These are not the same as the statutory notice scheme, the NTOs. This is not the same as Materialman liens. This is something completely different. But that preliminary lien is something which must be filed within 30 days. You probably will need an attorney to help you with this. And it basically is sort of a pseudo lien against the project. So in other words, at the end of the project, they cannot close out the project until they get a release from whoever filed the preliminary lien. We tend to recommend those in high risk credit situations and also large amounts, say, lumber supplying on a multifamily complex that gets into 6 figures. You may want to file a preliminary lien that just, hey, can't close out the project till we're paid. Obviously, during the project life, it is so important to submit timely and complete payment apps. But more importantly, you must monitor lien waivers. In Georgia, we have a kind of a complex lien waiver system. They are contingent upon payment for 90 days. After 90 days, they convert to no contingency. So if you sign a lien waiver and you are not paid in full, then in 90 days, if you haven't taken certain steps, you will lose the right to file a lien for that amount. Then the way the certain step you need to take is file an affidavit of non-payment, and that must be filed within 90 days of the date of the unpaid lien waiver. So in theory, if you're not paid for 3 or 4 months, you may have to file an affidavit of non-payment for a lien waiver you signed 65 days ago. Then maybe you give them another week or 2, then you file a second one for the other pay app / lien waiver. But it's very important to monitor those. Then project completion. This is where things get ugly if you don't get paid. But in Georgia, filing Materialman's lien is a great option. They're not terribly expensive to file, but they must be filed within the 90 days of the last day worked. It is not an invoice date. It is not a warranty work date. It is 90 days from the last day you were physically on the job or physically delivered materials. Similarly, if you have a payment bond, and this could be on a municipal project, this could also be on a private project. We see a lot of payment bonds on large private projects. You generally have 90 days from the last day of work to make a claim against the bond. If there's a payment bond on a private project, you can file a lien and file a payment bond. So think about it. If you did your due diligence, if you got a guarantee, if you got maybe more than one personal guarantee, if you have a payment bond claim you can make and you can file a lien, suddenly you're bringing a lot of people to the table to make sure you get paid. You've got the person with whom you've contracted, you've got the owner, you've got a surety, you may have a principal or a principal's spouse of the company with whom you work. All that helps to make sure you get paid. If you do file a Materialman's lien or make a payment bond claim, you basically have 1 year to file a notice of action, which is generally a lawsuit or a demand for arbitration. And so make sure you do that within 364 days of the date of filing. After you make that filing of a lawsuit or demand for arbitration, you then have to follow up in the lien record within another 30 days to file a notice of filing of action to enforce lien. And that will allow you, that basically perfects the lien for you and then allows you to foreclose the lien down the road. So our last slide just has a couple of these deadlines, hopefully easy on the slide for your future reference. But send an NTO within 30 days, do a preliminary lien within 30 days, both of those from the start of the day or start of work. Affidavit of non-payment is 90 days from the date of the lien waiver, not the last day of work, but the date of the lien waiver. The liens have to be, liens and bond claims are 90 days from the last day worked. You have to commence an action within 1 year, and 30 days after filing an action, you have to file a document called a notice of filing of action to enforce lien. And so I went through these very quickly. I think it's been 21 minutes, but I think Ariella and I are now available for any questions that we may have.
Wonderful. Yeah, thank you. You did such a great job. And so far, we don't have any questions, but on the right hand of your screen, you'll see where you can ask a question if you have one. And I know that sometimes after the webinars, people have a question. They say, oh, goodness, why didn't I think of that before? But feel free to send us an email and we will be happy to answer any questions you might have. And it looks like, Mark, that right now we don't have any other questions. You did a wonderful job. Thank you so much.
Well, I spoke quickly. I tried to pack in a lot because I do think these 20-minute webinars are great. They're surgical. You can discuss just the most important points, and it's great for employee training. So I appreciate everybody coming and participating. You're welcome to email me or call me with any questions too.
Thank you so much. I hope everyone has a sunny day. Thank you.